hear us? Morning. Well, technically it's afternoon, folks. So, hello. So, you're all on time, which is marvellous. We've got some international attendees. Welcome. So, obviously today we're talking about challenges for 2023. So firstly, very belated Happy New Year, but hey, it's the first webinar of 2023, so why not? The session is being recorded, so if for any reason you need to drop out, there will be a recording made available on our YouTube channel, and it will also be on our website. So for those of you that don't know me, my name is Kelly Peters. I'm one of the co-founders of Databasix.
And I'm Regina Jonas. I'm the other co-founder of Databasix, and joining with Kelly, which I haven't done for a long time. So I thought I'd put my 2 pennies worth in for 2023.
Yeah, so you get a proper double act today. I apologise for any crazy in advance that might happen. So before we kick off onto what are my discussion points, I'd be really interested to know, in the chat box, if you can you just type what you think are your data protection challenges for 2023, and hopefully we've got some of those covered in today's session. So we'll just give you a minute to type in what are your data protection challenges for the year ahead. I can see some typing, so.
And I think if we don't cover it today, it gives us good ideas for what to cover in future webinars. Though we can't extend time in the day, sadly. We'd like to be able to do that, Helen. But,
yeah.
Unfortunately.
If anyone does know how to pause time, can you please let us know? We would be all on board that.
Okay, so yeah, international transfer assessments. We're picking up that.
Okay, capturing data through websites, pulling together data protection impact assessments, pausing time with coffee. Oh, well, that's a winning idea right there. Keeping pace without Brexit. Nice.
Yeah. So I think we're picking up on some of those today, which is good. And like I say, we'll have a look at the transcript, and anything that we don't cover today, it'll certainly give us ideas for things that we can pick up in future webinars over the coming months. But yeah, excellent.
Awesome.
There's the common themes coming through, which is great to see.
Excellent. So let's kick off. So I highlighted 5 areas that I run past Regina and said I think these are good topics for discussion. If you have joined previous years, you will know that a typical one I like to talk about is the global world of data protection, because it is becoming more and more important and more countries adopting it. So it's if you want to know what I said last year, feel free to look at last year's webinar. We will cover what's going on in the world of Europe, because even though we have left the European Union, we need to be very mindful about what goes on in Europe, because a lot of us have European customers. So we need to be aware of that. Regina and I are going to talk about some of the guidance that's coming out from the Information Commissioner, and then a little bit on UK data protection, and then the joyous subject of international data transfers, which I know some of you have already said is on your challenges for the year ahead. So let's delve properly into this and kick off with the ICO's employment practice guide. So Regina.
So for any of you who come to our best practice groups, it's something that we did pick up on in the autumn and flagged that the ICO are looking at improving their guidance that they make available to organisations to help them with the introduction of new ways of capturing personal data. So one of the things that the pandemic saw was an inclination towards organisations wanting to be able to monitor their teams and their people more, to understand more about what was happening, particularly around working from home and productivity. And some of those were implemented without much thought to data protection or privacy. So I think the ICO has picked up on this. It's trying to provide very practical guidance around what constitutes monitoring at work. So what do you need to be thinking about? What are legitimate cases for monitoring, and where are you actually overstepping the line? And things that if you're considering introducing that type of monitoring, what do you need to do to make sure that you're staying on the right side of data protection legislation? So it's always about that, as with anything, it's always about that balance between what you as an organisation want to achieve and then the rights and freedoms of your, in this case, employees, the individuals who are working with you. You might also need to consider members of the public, depending on what kind of monitoring you're doing. And the key element is really about that transparency. So this piece of guidance was out for consultation throughout the autumn, and it closed last week. So the next kind of steps we'll look at finalising that. They'll look at feedback that's come through. They were also asking for some examples so that they've got some use cases where they had gaps at that time. So again, it will be updated probably in the next couple of months with a more final version. So some of the key tips that we've pulled out from that guidance is that you do have to be very clear about your purpose. As with anything, when you're processing individuals' personal data, you can't just do it because you fancy it or because you feel like it. You have to have a genuine purpose. So what are you trying to achieve? Are you trying to ensure health and safety is being adhered to? Are you trying to understand more about how your processes are working and whether or not they're efficient? Is it for security purposes and making sure that, you know, the security of your employees is being managed effectively? Is it about productivity? You know, or are you looking at trying to monitor people's behaviour? And all of those will have very different outcomes as to the level of intrusion having on your employees and their privacy.
And one of the really good examples that they talked about was the difference between you switching on, you've got an employee working from home, you switch on their camera of their laptop and you're monitoring them. So you're delving into their kind of home and you're looking at what they're doing, versus is there an alternative way in which you can capture that productivity kind of data, or, you know, log in and watching how many keystrokes that you're doing, because you may not have considered the fact that someone needs to take time away from their computer to be thinking about what they are going to be producing. So you really have to take into consideration the individual's role and what they're doing before you go down that route of really being invasive. So that's where they gave some really awesome kind of scenarios about legal basis and about fairness, that I think if you have implemented stuff, I would recommend that you go back over that guidance and just take a look to say, you know, can we genuinely demonstrate fairness? Have we demonstrated transparency with that? So I would urge you to take a look at the guidance, because the examples, I was really impressed with the examples they gave.
Absolutely. And obviously then wherever you've got that purpose, you need to make sure you've got the right legal basis. I think it's, in most cases, it's unlikely to be consent. Because of the imbalance between the employer and the employee, they're probably going to feel an obligation to say yes. So you can't justify that as legitimate consent under GDPR.
Yeah.
So you're going to be looking for a different legal basis. Remember, if you're doing and relying on legitimate interests, you need to be doing a legitimate interest assessment. And don't forget that you might inadvertently catch special category data. So you might not be anticipating it, but there may be ways that you capture that. So one of the examples I think they give is around if you're monitoring individuals' emails, yes, for example, what you might then capture is information, that a conversation that somebody is having between themselves and their union rep. That's special category data, because, you know, they're within the union, you're capturing that conversation and it's not something that you should be privy to. And you'd have to be very clear about the restrictions and how you can and can't use that information. So you have to sort of foresee those scenarios that might be one-offs, they might not be routine, but that you might then be actually capturing special category data. You know, if you think about images and CCTV, you might be capturing somebody's disability if it's a physical one. So you need to think about what you're going to do with and how you manage that special category data, as well as the more routine stuff. And so for that reason, you know, and I think because it's potentially intrusive, they do recommend that you should do a data protection impact assessment so that you fully understand the risks of the monitoring that you're introducing, that you understand where there might be the intrusion on people's privacy, your employees' privacy, and how do you manage that? How do you make sure that you've got the mitigations in place to reduce those risks? So I think that's key. And again, as Kelly said, the scenarios that they talk through are really helpful for all sorts of different types of businesses. They do give some very clear outline as to what they consider to come under that definition of monitoring technologies. So there's some obvious ones around things like body-worn devices. There might be webcams that you're looking at or taking screenshots. There are those the sort of more tools out there, technology tools around tracking keystrokes and what people are doing on the internet. There are timekeeping tools, productivity tools. You've got the physical ones of clocking in, clocking out systems, and much more sophisticated ones that have been introduced, particularly over the course of the pandemic. And so you need to really think about, what is it you're trying to achieve? Does it fit that purpose? Things like, if you think about vehicle trackers, then if you're looking for the security of the vehicle, to make sure you know where people are, not people the vehicle is, and it's that security so that you can bring it back, great. But if you're then going to use it to track, well, what are the routes people are taking? Are they working? Why have they sat there in that lay-by for half an hour? That's a different purpose. And you need to be very clear about how they're separated, the legal basis you're relying on for each purpose, even if it's the same actual monitoring technology. So again, really think through what you're using, why you're using it, and is it the most appropriate way of achieving the objective you want to achieve with that, the monitoring. And make sure you have consultation and discussion with your workers. It can't be secret. It needs to be open, transparent. You need to be very clear about the purposes and make sure that they understand, and that you then are updating things like privacy notices, your employee privacy notice, to make sure it's very clear about what you're doing and what you're introducing and why.
Yeah, and certainly if you've got things like cameras going on, that you should have, anything CCTV should have a notice by that. If you're doing any kind of audio recording, there should be a notice in advance that the individual is aware that the call is being recorded. There was a really good example about dash cams and in-car recording, and whether or not you turn on the audio or not. So you've got, very much like Regina said, is, people need to know that they're being recorded or their data is being captured. So you need to present them with that information in advance, so they're not taken by surprise, because it shouldn't be covert in any shape or form. So alongside that piece of guidance that the Information Commissioner has released, they've also just closed a consultation on workers' health. Now, the guidance is very clear that a worker isn't just an employee. They can be anybody that is a contractor, a volunteer, or a gig worker. So they use the term worker throughout the guidance. So even though it's employment practice guidance, we are talking about workers. So just be mindful of that. So I'm going to come back to, there's a question that's just come up. So we'll come back to that question once we've just gone through these employment slides, and we'll aim to answer that. So there may be many reasons by which we, as employers, wish to collect information on health about workers. It may be contained in sickness and absence forms. It may be about results of fitness to work, for example. It may be about how you need to make work adjustments to be able to ensure that anybody that has an impairment can work. It's possibly recording vaccinations and immunization, possibly results of a drug and alcohol test, but very much like what Regina was talking about in the monitoring, you have to have a really clear purpose about why you want this, because this is special category data. You need, not only do you need a lawful basis, but you need a condition as to what you're going to rely on to capture and use this special category data. So if there are alternative ways in which you can get the information, then do. So you wouldn't necessarily want to see a medical record of an employee. You may simply need a conversation with their GP to have an understanding of a summary of that individual's health and fitness, to be able for them to be able to perform their job. So always be mindful about what you're collecting and why you're collecting it. And if you can't justify it, you're not going to get past the fairness, lawfulness, and transparency principle of the law.
I think the other thing to think about is whether or not you need it for everybody. So one of the examples that was kind of really good to use is if you've got, say, a production area and an office area, It might be that some of your production team are using forklifts, and then there's actual information you need to go through and check with them about their health and their status and medication to ensure that they're using forklifts in a safe way and that they're safe to use that equipment in the workplace. Now, what you don't want to do is to introduce that for all your staff. It's not relevant for the office-based staff. It might not be relevant for all your production team. So what you then look to do is to, at the point you're identifying an individual is putting themselves forward, or you're selecting them to be able to drive a forklift, you could then ask them the medical questionnaire at that point for that small selection of workers, so that you're actually only keeping it relevant to the team and the individuals that you need it to, and you're not just putting a blanket health questionnaire in across your entire team where it's totally unnecessary for what you need to achieve. So it's that type of sort of good practice that you can look to implement. And again, there's some really good scenarios in this guidance.
Absolutely. And we've got another question, so we are going to come back to both those questions in a quick second. I think the really pertinent point about this policy is about being really clear about what you're going to use the data for now, not thinking about, oh, this could be useful in the future. It's always about, if you think about the data minimization principle, is very much, what do you need right now to make a decision? If you don't need that health information now to make that decision, you shouldn't be collecting that. It gives you a whole raft of really good principles, also really good examples of what is fair, what do they mean by lawfulness, and they talk you through why consent is unlikely to be an appropriate basis, why legitimate interest may be possible, but it's not always going to be an option. If you're going to rely on something that's set down in law, what is that legal framework that you're relying on? You can't simply say it's a legal obligation. You have to say it's in relation to the Health and Safety Act and this part of that. So you have to be very clear in your documentation what instrument you're relying on, and if it's an employment contract, what are those conditions? So be transparent. And what I found really interested in, and we talk a lot about employee exit and data protection, is when that employee finishes working with you, do you need everything in that HR file? Are there pieces of information that you could remove that you no longer need, that's not going to serve you in the future if you were to get a future litigation? So be mindful that if there's health information in that file that you don't need anymore and it's never going to come into question, remove it at the point that that employee leaves your organization to move on to another one. So I liked both guidances. Both might be applicable to you in terms of your work environment. Yes, they are still in draft format, but I would say have a look. If there are going to be any tweaks, they're going to be likely to be minor, but start thinking about it now if it's something that you're considering for 2023. So we have two questions. So what happens if it's found that an employee has covertly recorded conversations? Now, you do need to be mindful of whistleblowing policies, and obviously we do need to protect individuals' privacy. So I'm pretty sure there was some guidance that said that if the individual has made that decision to record that, they are the data controller of their own phone and that decision to record that data, and they might be using it for whistleblowing purposes. They don't, I think what the guidance was, they don't necessarily need to tell you that they are recording it, which sounds ironic, bear in mind I've just told you about transparency. But there is, you have to think about why are they doing that? What are they trying to prove and they're trying to demonstrate? And if it is to do with whistleblowing, then they do have that right to be able to capture that information. In terms of pre-medical checks before someone joins an organization, it can't be a precondition of kind of joining your organization. So if they don't share information with you about whether or not they've got diabetes or whether or not they have a pacemaker, then they're not going to share it. So for me, always what's the purpose of the pre-employment questionnaire? That purpose will then allow you to have the conversation about what's the legal basis for that and really justify, can you collect that information? And then that will help you be transparent in terms of what you need to present as part of your applicant privacy policy. on that. So hopefully that makes sense.
And I think there's that element as well, as it could be that you only do it for people that you're offering the role to, so that then it's very clearly about you're not using it to make a decision about who's offered the role, but it's more about what allowances do you as an organisation need to make for that person coming into your organisation? How do you accommodate any issues that they might have? How do you inform the first aiders? And again, it's that transparency with them about what data might be shared with other members of the team and why. So again, if you're, if we've got an EpiPen and you need to share that with first aiders or their immediate team so that they're aware of what to do in the case of emergency, again, you would make that clear to them so that they're very, it's that open, honest conversation about this is the data we're asking, this is what we're asking, and this is what we're going to do with it. And then they'll feel more able to trust you and feel comfortable sharing information in that way.
Absolutely. And then there was another question, and then we'll move on to UK data protection. It's if you have CCTV and notices are displayed, which is fantastic, is it okay to look at the footage from the app or from a mobile device? All I would consider that you think about is the app that you're accessing the CCTV from. Have you read the privacy policy of the app? It sounds really silly, but just be mindful about the secure nature by which you're accessing that. And is it storing anything that you're viewing on your device? So you just need to make people aware. And who are you providing access from that app to? So is it just a limited number of people? Because that's what CCTV should be. It should only be those who need to see access to the CCTV have access to that. So I would just ask you to consider what's the app and the security of that app. Does it download and store anything onto the device? And how are you restricting who has access to that app? So moving on to the world of local UK data protection. Some of you may remember that I was about to do a webinar in September, and I was going to be talking to you about the Data Protection and Digital Information Bill. It was about to go through to its second reading. And then we had one of the many changes in government last year, and essentially it was put on hold. Now, the status is that is still on hold. It hasn't been removed entirely. There are whispers and gossip, for want of a better phrase, that indicates that this is something that is still on the cards. It is going through a revision, if I can get my teeth in, and is likely to get pushed forward later this year. We don't know when that will be. So really, this is about being mindful that there can still be a divergence between UK data protection and what is going on with Europe and what we currently have in place at the moment. So watch this space. If anything does change significantly, we will do a webinar on it. But there is going to be likely movement on this. So bear that in mind. The other thing to be mindful of is that there was a lot of debate in the summer last year about the online safety bill. It hasn't yet been passed. There was conversations and requests to make amendments to that because some pundits were very unhappy with what the online safety bill was offering. The premise is it should make it the internet safer for all users, regardless of age and ability. But we are expecting a revision and progress this year. So where you do, where this bill might apply to you, be mindful of that. I would also say as an aside, which I hadn't covered in this, is that the ICO are actively promoting a lot of their the children's data protection element, and really trying to make sure that people are aware of what their obligations are for young people, and internet and applications that are being provided to young people. So if you do offer services to young people, and this is anyone under the age of 18, don't just concentrate on looking at data protection and online safety. Do look at the children's code that fits as part of UK data protection, because there's a lot more messaging coming out from the government at the moment about the do's and don'ts of that. And then finally, there is this possibility and I'm hoping it doesn't happen, that all EU retained law is essentially removed and thrown out of the cupboard in the UK, and we no longer have that law to refer to. We're talking about a significant, I think there was thousands of pieces of law, and data protection is just one small nugget of that. There are much more significant pieces of legislation that are considered to be taken off the table if nothing is done about this. We believe there will be a decision made to retain EU law, because I think it makes sense. But watch this space. If EU law is not retained, then UK GDPR and PECA will be waving goodbye, along with a lot of other policies. So
the Data Protection Act 2018 would remain.
Yeah.
It just probably wouldn't make a lot of sense where it refers to GDPR directly within the legislation, which is probably the problem that they have across multiple laws, where they all are entwined. And yeah,
trying to unravel that is a nightmare that I'm hoping they're going to not do.
So one of the things that came out towards the end of the autumn, I think it's about October time, was an announcement that the UK and US governments have been discussing the progress of a UK and US data adequacy agreement. There was a sort of a press release that said it was imminent, but obviously we don't quite know what imminent means in terms of those kind of discussions. But I think it's interesting to note that progress has been made, and that there's that move to want to get data adequacy with the US. I think, we all know how much data and how many applications and online packages do host data in the US. And I think it's a challenge for most organizations to think about, can we actually do this? A lot of organizations don't, if I'm perfectly honest. I think a lot of people don't read privacy policies. They don't understand their data is leaving the country. And I think looking to try and actually get a more formal agreement in place would be beneficial. I think until that point, until it's made official, obviously you still need to consider, if you are using new apps, if you are using new online cloud solutions, you really need to think about that data that is being transferred to the US, and are you comfortable with that? It might be that for certain types of data, there's low risk and you're happy with it. It might be, as is the case at the moment, most people dealing with legal-based data, most people dealing with anything health-related are reluctant to store that in the US because of the greater powers that government have to access that data without real justification. Alongside us, the EU are also talking about establishing a new framework to replace the Privacy Shield, which was defunct from July 2020. If you do refer to Privacy Shield anywhere in your own privacy policies, or you see it online, again, that's not a up-to-date valid framework to rely on. So you need to be looking more at standard contract clauses, which we've got other webinars about. So the two are happening in parallel, and obviously it would be good if they got agreed relatively simultaneously in that ideal world. If one goes before the other, keep an eye on it, keep an eye on what's happening, particularly if you have European clients and we agree that first. You may have to have different processes, different considerations, continue to consider the EU element of EU citizens' data that you're transferring to the US, and what you might need to do, and if that differs in any way at that point. So again, as that gets agreed, it'll be something that we'll be looking at and looking to do a webinar on, or share that with you. So we'll keep on top of it. But yeah, for the moment, it's still being discussed, but it's looking more promising than it has for some time. And then just to talk a little bit more about the United States, if you do market or work in that area, then you do need to be aware of the increasing level of data protection legislation that's appearing, particularly this year. And that where it has existed, it's getting a bit tighter. So the California has already had the California Consumer Privacy Act, CCPA, and is now introducing the California Privacy Rights Act. So that takes out the term consumer. So it widens and strengthens the privacy rights of individuals. And so again, companies need to be thinking about, if you're working in California, if you're marketing to California individuals, what do you need to be considering, what do you need to have in place? Do you have that available? So some of the very simple things around things like your privacy notice, do they comply with what the requirements are for California? They've got some slight differences around things like do not sell, do not track, and you need to make those available. So if you're working in that space, have a look at what's required and make sure that you are compliant. And similarly, the Virginia Consumer Data Protection Act came into force earlier this month. It's very specific around who that's targeting and the companies that have to comply, in terms of they very much look at the volume of data that you are processing. So if you're processing, I think it's over 250,000 records of consumer data, then you need to be thinking about how you're complying with this. There's a couple of criteria in place there. So again, it's about looking and saying, do we hit this criteria? And if so, what do we need to do? Nevada have one coming in June later this year, and Colorado as well. So think about the states. They are looking at an American Data Protection, Privacy and Protection Act, but I think getting something in across the country might be quite challenging, and particularly with some of the politics in the states and how things sort of are being blocked at the moment, it's unlikely to pass. But each state is able to pass their own legislation, and so there might be slight differences between the states. But California is definitely the one that's had the longest legislation in place and is updating it, and is probably the most strict. So have a look if you are working in the States, make sure that you're keeping up to date with what's going on there and making sure that anything that you're putting out that way, that you're complying with the legislation.
And then,
No, that's fine, you carry on. I'll hand it to you.
I was confused who's doing what slide. It's probably me. So I read a really interesting statistic that said by next year, 2024, 75% of the globe will have some type of data privacy regulation in place. That's phenomenal in terms of how far we've come. So a lot of questions we get asked is, does data protection apply to us? If we've left Europe, data protection doesn't really matter anymore. And in actual fact, we are in a global marketplace. So we do need to be mindful that not only do we have our own regulation to consider, if we are going to be marketing or selling or engaging with individuals in other countries, we have to take a look at what their legislation says when it comes to data protection. So if you're interested in terms of, well, where does that, what does apply, what's in place, the Department for Digital, Culture, Media and Sport did produce, it is a beast of a report, I'm not going to lie. It's called The Extent and Impact of Data Localization. So what is data localization relates to data protection regime in that country that you're looking to enter into. So please make sure that if part of your strategy is go global, factor in data protection into that. You can take a look at that report. It's got a whole lot of tables in that. There are other websites out there that will give you a comparison that you can compare where we are in the UK, and you might be able to select another country like Australia, for example, or if you are looking to, go to one of the South American countries, for example, you would be able to select that and do a comparison. And I think the one that we've used in the past is a DL Piper, isn't DLA Piper website.
And that's really helpful because it breaks it down by different aspects. So you can see the overall legislation, you can see marketing requirements, you can see anything that's particular in terms of, electronic marketing. So, as we have with PECA, that you might need to have consent if it's consumer-based data. What are the rules out there? And it just helps make sure that you're complying in the different markets you're working in. And there's some that are quite different. So I think in the UAE, there's particular additional regulations around finance-related data and what you can and can't do there. So I think for those working across sort of multiple boundaries, it's really helpful to think about that. But I'd say sort of generally that the gold standard is seen as GDPR, and a lot of countries around the world are basing their updates on that. So a lot of African countries are combining the South African data protection legislation with GDPR, and so you end up with a bit of a mix of the two. But it is worldwide, and I think there's no escaping from it, as much as you'd like to.
And then you'll know that some people are not too bothered by cookies. Other people get really infuriated by some of you may have got frustrated by cookie walls or by this incessant need for vendors to tell us that they have a legitimate interest to process our cookies. Doesn't make us happy as people when we see it. And I will typically switch off of a website if I am presented with that. Now, what's really quite interested in is very recently the European Data Protection Board has made and has issued guidance on cookie consent. So what it has said, it's been very clear in terms of what its expectations are of organizations when it comes to your collection of cookies and how you present choice to individuals when they are visiting your app or your website. So they have been very clear that you have to make a reject button, has to be displayed at the first layer of the banner. So there should be no hiding of it. You shouldn't have to click multiple places to get to that reject option. It should be front and center. You accept, reject. Along that, there should be no deceptive colouring. So you shouldn't be using green as a this is the right choice and red, this is the wrong choice. It should be no deceptive colouring to distract the individual about what you're asking them to decide. Don't have pre-ticked boxes. So there are still people that were like, oh, yes, you have advertising and marketing, and they've ticked the boxes for you and you have to go in and untick it. Not cool. And as I said, legitimate interest is not a valid basis for processing cookies in any shape or form. So,
and I think I find media websites the worst for this.
Yes.
So a lot of the lower ranked newspapers, sort of local newspapers, or a lot of the television site. There's so many, but it will typically be sort of magazine-based, article-based websites that then have all of this long list of vendors that are relying on legitimate interest, and they don't have a reject all button, and I will leave the website because it's frustrating and it's not legal.
So we'll move on from that before we both get onto a mega rant and we've lost all of our audience because you've gone for lunch. The other thing to be made aware of is that Europe have got a whole swathe of legislation that they are looking to roll out in the next year to 18 months. So you're seeing artificial intelligence is on the rise. There's a lot more products that are using that either within the system, or they are using it as to help support automated decision making. So in Europe, they have created this Artificial Intelligence Act, and its aim really is to ensure that any systems that are being offered into the in the EU market are safe and respect individuals' fundamental rights. So if there are algorithms that are being used, there must be the ability to be able to speak to a human being. You must be able to understand some of the logic that has been applied. So we need to be mindful of this because a lot of companies are really excited about where AI can take us and how it can revolutionize products and services. That's great. Be mindful of the legislation that may affect you and what you'll need to demonstrate and how you comply with that.
I think for me, one of the biggest challenges is if you think about the individual rights, one of those is the right to sort of challenge automated decision making and profiling, that you're able to have that decision making process explained to you, and you're able to speak to a human, as Kelly said. But also one of that element is around you being able to explain the algorithm and to explain to an individual what's happening with their data and how it's affected. And I really question how many organizations are going to be able to do that, to be able to do it in a way that they will understand themselves, but also how their customers and stakeholders will truly understand. And I think that's a huge challenge for the AI industry, as well as those who are buying products with it brought out. And yes, the whole ChatGPT.
We don't have enough hours in the day to talk.
Bubble that is going on at the moment I think it's one such example, and it's interesting for sure. And I think there's a lot of hype around it, but being able to explain what's going on in the background there, and how that's using personal data, and is that legitimate, and what's the decision making, all of those kind of things. I think that's a huge challenge coming up in the next few years, not just 2023.
Yeah, no, absolutely. We'll come on to the quick question that's come on about cookies and third parties in a moment, if that's okay. The other acts are the Data Act and data governance, and this is really aimed at predominantly the public sector, and it's about making sure that we improve and we are very clear about how data is going to be shared and the governance around that data and organizations. So that excites me a lot, because I think that not everybody has a standard approach to data sharing and what are the rules around that. In this country, we have called guidelines. If you work in the NHS, so not only do we have data protection, we have a set of principles that we have to respect when it comes to NHS and public sector data. So again, if you're a public body, be mindful of these two pieces of legislation. And then the Cyber Resilience Act is really about, it's covering the Internet of Things, because, today your fridge can make decisions about you. You've got all these different pieces of technology in your house. And what the Cyber Resilience Act is really trying to make sure is that we are reducing the risk, and those offers, the products that are being offered to individuals, that they have been well thought through, and that we are not putting individual consumers in their home more at greater risk of a cyber attack. And I've got e-privacy on here because it's a constant thing that's talked about. Yes, it's the potential for it to be rediscussed in Europe, and e-privacy is the cookie and electronic privacy regulation that we rely on in this country, PECA. But who knows? It's there.
It's been being discussed for
a long time.
Pre-GDPR. So
yeah.
Whether that will get passed and through this time, who knows?
So we had a question about third party and tracking cookies that are used by the third party. The reality is that they're not strictly necessary, because you've got no control over those. Strictly necessary cookies are described by the Information Commissioner as those that help you kind of the load balancing of your website, for example. A strictly necessary cookie could be maintaining the security of your website or your application. For example, it has a very finite list of what is classed as strictly necessary. Everything outside of that, if it doesn't fit that criteria, you need consent. And if you're placing third-party cookies on the website, then again, you need to give the person the choice as to whether or not they accept those cookies, which is where this whole legitimate interest carnage comes from, is because third parties think that they do have a legitimate interest to have your data, and that's wrong.
Absolutely. And the other thing to be mindful of is that if you've got a cookie that's got a dual purpose, one of which is strictly necessary and one of which is not, you then still need consent. So they're very clear about that just be mindful of if there's a double purpose for that particular cookie. But anything that's going to be tracking or behavioural is likely to be unnecessary. Interesting for us as business owners, of course. So Google Analytics, not necessary. Much to many marketing agencies' disgruntledness, but it's true, it's not necessary, it's a choice. Facebook Pixel, anything like that, then anything that's tracking somebody's behavior around a website or where they go after, particularly because that informs marketing, advertising behavior, future images that they'll see, it's not necessary, and they've got the right to refuse those cookies and not give you consent to accept them.
Cool. So that kind of gives us like about a minute and a half before we wrap up today's webinar. I hope it has been useful. Do pose any questions that you might have in the chat box. If we don't have a chance to answer them, we will come back to you and take them offline, because I want to respect the fact we said it was going to be 45 minutes. What I would like to say is, obviously, hopefully some of you might start become familiar with our new branding in terms of the data Rockstars. If you have a data protection query, I hope you feel that you could reach out to me or Regina, give us a call, check out our website, or email us. We're always there to help out. So yeah, I want to thank you, Regina, for joining me.
Yes, there will be a recording of the sessions, so it'll be on our YouTube channel. Normally early next week. And I think you also get it sent to you because you've signed up. I think
Yes.
it comes through to your email anyway. So glad that it seems like you all enjoyed it.
And yeah, thank you very much. Enjoy the rest of your afternoon. I hope it's afternoon for everybody that's on the webinar. Have a great one, and we'll be running another webinar in the future. So